Hello, hello, hello. It's Attorney Mike Revel coming to you from Beaufort, South Carolina. I don't know if I'm even saying that right. I don't know. Here I am. Had a good time. Thanks again to Biggin. We did a little walkabout in Charleston this morning. He gave me a lift up to Beaufort. Here I am. And I also have to thank Kristen, who sent me these videos. It's a good thing because I've been on the road, so I haven't had time to look at anything. In fact, I haven't watched most of them, but what I've seen is pretty good. The first video she sent me, she sent under the title, "This video sucks." And when you see it, you'll understand why. Let's do it, shall we?
Can we do this today, Your Honor? My health is in jeopardy right now.
What's that?
I have IBS, irritable bowel syndrome, and what's been going on is
Very stressful.
I'm bleeding inside, ma'am.
For a plea and potentially sentencing hearing all at the same time. Am I correct in that assumption then today,
Buckle up, people.
Attorney Muir?
Yes, Your Honor.
All right. Attorney Cass, Attorney Muir, who would state the terms for the record, please?
Thank you, Your Honor. In exchange for an acceptable plea to the amended charge of disorderly person, the people amended accordingly. Additionally, we do not object to a request for community service work in Monroe Jail.
Were you able to hear that, Attorney Muir?
I was, Your Honor.
Is that your understanding of the agreement?
Yes, Your Honor.
All right, Mr. Quistorf, is that your understanding of the agreement?
Yes, it is, Your Honor.
And what is your full legal name, please?
James Dean Quistorf.
Quistorf. All right, Mr. Quistorf, I have in front of me an advice of rights and plea information form with your signature. Did you understand all of your rights contained in this form with your lawyer's help?
Yes, I do, Your Honor.
All right, then. Concerning the matter, Mr. Quistorf, do you understand you have the absolute right to have a jury trial in your case, and in some instances you have a right to a trial by court? Are you aware of that?
I'm aware of that. Thank you, Your Honor. Yes.
All right. A motion to amend has been filed by the prosecuting attorney's office, changing the charge from aggravated indecent exposure to a charge of disorderly person, obscene conduct. The maximum penalty for that offense is up to 90 days in jail and or up to a $500 fine plus court costs are added on. The court shall order law enforcement to collect a DNA identification profiling sample. Additionally, there could be what we call collateral consequences, Mr. Quistorf. For example, you could have difficulty entering into a foreign country as a result of this conviction. Or if you're not a citizen of the United States, a conviction could result in removal or deportation from the United States, exclusion from admission to the United States, and or the denial of naturalization. Do you understand the nature then of this amended charge and the maximum penalty?
Yes, Your Honor, I do.
To the charge as amended, what is your plea?
I plead guilty, Your Honor.
All right.
Okay, so here we are. I seriously, I'll give a warning here. It's not that big of a deal, but this factual basis is not for the squeamish.
Then, Mr. Quistorf, before I accept your guilty plea, I want to make sure you understand the rights you're giving up by pleading guilty. Do you understand then by pleading guilty, there's not going to be a trial of any kind?
Yes, Your Honor, I do.
And do you understand that if you had chosen to have a trial instead of pleading guilty, you could have exercised each of the trial rights that are listed in this advice of rights form that you signed?
Yes, Your Honor.
And do you understand the consequence of pleading guilty is that you give up the right to exercise each of the trial rights listed in this
Yes, Your
form?
Honor.
Do you understand the court is free to impose any sentence that the court feels is appropriate up to the maximum provided by law?
Yes, Your Honor.
Mr. Quistorf, understanding that and the other things I've been over here with you, does it remain your intention to plead guilty?
Yes, it is, Your Honor.
Are you presently on probation or parole to any court?
No, I'm not, Your Honor.
Outside of the terms placed on the record, has anybody promised you anything in order to get you to plead guilty?
No, they have not, Your Honor.
Has anybody forced you or coerced you in any way to get you to plead guilty?
No, Your Honor.
Has anybody told you the courts would simply be more lenient with you if you pled guilty?
No, Your Honor.
Are you pleading guilty freely, voluntarily, and understandingly?
Yes, I am, Your Honor.
You a whore.
All right, then, Mr. Quistorf, we're going to make out the elements of the amended offense for the record. The complaint indicates this occurred on or about September 7th of 2023 in Brighton Township, Dickinson County, State of Michigan. Do you agree with that?
Yes, Your Honor.
And concerning this amended offense of disorderly person, in your own words, then what did you do that constitutes this amended offense?
I went to the park and there was a man sitting on a bench and he asked me what I was looking for and my response to him was to suck. And he said, well, let me make myself more comfortable here. I proceeded to get down on my knees in front of him and he replied to me, oh, you want to suck? And I said, yeah, but this isn't going to work. And I proceeded to leave. However, I really believe that that conduct was disorderly and obscene. And I accept the charges against me.
Words that she said, or
Sure. I need for you to tell me what went on.
that I'm not on that whole shit. I'm not with that whole shit.
The charges.
All right, and was that in a public place here in Dickinson County?
Yes, it was.
It was
No, not near the falls. I don't remember the name.
hydraulic falls
Hydraulic Falls Park.
in Brighton Township?
Yes, ma'am.
All right. All right, so you're satisfied then that the words that you utilized and or the conduct was in fact indecent or obscene in a public place?
Yes, Your Honor.
I think that's a sufficient factual basis for the amended charge. Are the people satisfied?
Yes, Your Honor.
Are you, Attorney Muir?
Yes, Your Honor. Thank you.
All right.
Oh, that's more than sufficient.
Is either counsel aware of any promises, threats, or inducements in order to get Mr. Quistorf to plead guilty that have not been placed on the record at this time? Attorney Muir?
No, Your Honor.
How about you, Ms. Cass?
No, Your Honor.
And does counsel believe the court's complied with the taking of pleas under Michigan Court Rule 6.610? Ms. Cass?
Yes, Your Honor.
Ms. Muir?
Yes, Your Honor.
All right, thank you. For the record, I will find then, Mr. Quistorf, that you have made out the elements of the amended offense. I will also find that your plea this afternoon has been made freely, voluntarily, and understandingly. I will accept your guilty plea and find you guilty of that amended offense. Concerning sentencing, then, are you requesting to proceed directly to sentencing, Attorney Muir?
Yes, please, Your Honor, if we may. Mr. Quistorf is from California and has flown in for the hearing today. So if possible, that would be of great convenience to us.
All right, do you have an objection, Ms. Cass?
No, Your Honor.
All right, the pre-sentence report has already been completed by the probation department. Did you have a chance to review that with your client, Attorney Muir?
I did, Your Honor. Thank you.
Is there anything of a factual nature that appears inaccurate to you?
No, Your Honor.
Is there anything you'd like to say then on behalf of Mr. Quistorf before the court imposes sentence?
I would, Your Honor. Mr. Quistorf is an engineer. He's got an interesting job as a satellite engineer in California. He has a military grade security clearance. He's 62 years old. He has absolutely no criminal history whatsoever. He is extremely embarrassed about this incident. He has immediately gotten himself into counseling, which he continues to attend. He has been forthright and honest, as far as he tells me, with his family and friends and coworkers, some of whom have submitted letters of support related to his character and background. He has renewed his faith, which is important to him, and with the church, he has been participating in neighborhood outreach for the homeless population, city cleanup, things of that nature, all of his own volition. He has received, the letters of support that he received were from people close to him who've known him for a long time that he has let know about this offense, including his brother, a coworker, a neighbor who's an attorney friend, and then his longtime family friend who's, both of his children are Mr. Quistorf's godchildren. So people who know him well, who are able to attest to his law-abidingness outside of this conduct, his remorse for this conduct, and his otherwise good acts in the community. I know that this was somewhat of a sting operation in the park and that others were also arrested on the same day. However, Mr. Quistorf did not have any contact with those people until he reached the jail where they were all lodged together. And I'm not sure if his case is...
Oh, good Lord. They had a sting operation. Then they all got arrested and they take this crowd and put them in jail together. I don't even want to know.
similar or dissimilar to those cases, but I think it's worth noting that he did not have any physical contact or attempt to touch the officer in any way, which is verified by the drone footage that was provided to us in discovery from the day of his arrest. He has been compliant on bond and has flown in from California for this hearing. He flew in actually a couple of days ago to make sure that there was no weather-related delays or anything like this. He reports that he doesn't use drugs or drink. He cares for his elderly mother in Wisconsin. He's prepared to pay the fines today. He'll probably be getting a refund, it looks like, from his bond money, but he has money prepared to pay any extra anyway. And I did discuss the possibility of him pleading no contest, but he was adamant that he would prefer to plead guilty because he wants to take full responsibility and indicate that to the court. So with that, Your Honor, I appreciate the offer of no jail time. I hope that the court is amenable to that. In addition, I would request that the court consider a sentence that does not include probation.
Oh yeah, this is a sting operation with drones in the park. I don't even want to know what the operation was called.
For all of the reasons stated. And if there are any terms or conditions, I would just note the social media condition. The only app that he uses that he feels is necessary, which seems reasonable, is LinkedIn for work. This arrest in this case has already had some ramifications on his current job, and he may be using LinkedIn for an employment search. So if the court is to include any social media restrictions.
I feel horrible for this guy, but it should. If he's got high clearance and he has access to things, he can be so easily compromised with this scenario. I'm sorry, but you know, security comes before this other stuff. I don't think he's a bad guy, but he's easily compromised. It's just the way I see it.
Restrictions, we would just ask for an exception that he be permitted to use LinkedIn. That's all. Thank you, Your Honor.
Thank you. Attorney Muir, I'm searching the file. I don't see any letters of support in here anywhere. Was there something I was supposed to review?
They were late coming last night, Your Honor. I did email them in, but I'm happy to summarize them for you. There was one from his brother, William Quistorf, who just reported that Mr. Quistorf has always been, a good brother to him. Let me pull it up here. That he's truly family oriented, that he takes care of their mother in northern Wisconsin, that Mr. Quistorf, the defendant, is a Navy veteran who was honorably discharged, and that he has acknowledged this lapse in judgment as an aberration. The second letter was from a longtime family friend, John Vance, who is a 30-year veteran of law enforcement who has done a lot of detective work and attests that Mr. Quistorf is the godfather of both of their children and will also be the guardian if something were to happen to them, that Mr. Quistorf has always demonstrated a strong sense of honor and integrity and moral character. The third of the four letters is from the attorney friend whose name is Kelly Ray Wagoner, and she is the immediate next door neighbor of Mr. Quistorf for the past 20 years and a very close personal friend. And she talked about how they co-founded a neighborhood nonprofit organization several years ago that partnered with the local police and the Neighborhood Watch program to deter and reduce all categories of crime throughout the neighborhood, and that Mr. Quistorf was instrumental in working with the local police captain and leadership.
Did that extend to the parks, is my question.
To implement that, which resulted in a reduction in crime reports by about 50% in their neighborhood. And she says she's never known an individual so honest and committed to devoting their time and attention to helping the community. And she concludes, as an officer of the court in California, she would not ask these things or make this statement for anyone other than someone as truly wonderful as Mr. Quistorf. And then the last letter is from a coworker named Alexia Conrad, who says that she's been a work friend of Mr. Quistorf's for 30 years in the satellite industry, and that she works closely with him on a lot of projects. He's a hard worker. He is personally requested by foreign and domestic customers to handle really complex and difficult situations. She relies on him a lot for handling personnel situations, and that he's just a loving, attentive, and caring, empathetic person.
All right, thank you, counsel. I guess one of my only questions for you is that the recommendation is for a delay of sentence. I heard you say you were requesting a non-probationary period. Those two are incongruent. What are you asking for?
I would ask for a sentence of just fines and costs in this instance, Your Honor.
So he wants the disorderly person on his record?
What is I'm sorry, I must be I thought that only the jail time was suspended. Is this a diversion?
No, they were recommending a delay of sentence under 771.1, whereby if he completes his 9 months of probation successfully, this would not go on his permanent record.
Oh.
But if he doesn't,
I hope you know that this will go down on your permanent record.
We would take that, Your Honor. Sorry, I misunderstood that recommendation in the pre-sentence report.
And hell's yeah, let's do a diversion.
all right. All right, I'm assuming so, but I'll have a chat. You get to go last. We're going to see if Ms. Cass wants to say anything. And that's only not because you're the least important, because you get to hear everything that goes on. That's what the rules say.
Thank you.
All right, go ahead, Ms. Cass.
Thank you.
Unless there's anything else, Attorney Muir.
No, that was it. Thank you very much, Your Honor.
All right, thank you.
Your Honor, when the complaints came in for this park, the Sheriff's Department here took it very seriously, and we can only hope that their thorough investigation has led to a deterrent effect of this issue. It does appear the defendant has taken this very seriously and did seem quite forthright with his admissions right now. So we ask the court to follow the recommendations by the Probation Department.
Thank you, Ms. Cass. All right, Mr. Quistorf, anything you'd like to add?
Yes. First, I'd like to apologize to the good people of the County of Dickinson County and the citizens here, and for this court and your bench for having to bring this trouble to in front of you. I'm truly remorseful for my behavior that day. I take it very seriously, and it's led to a life-altering event for me, and one for which I'm very grateful. For all good things come to the good for those who love the Lord, and that's really where my heart is. And I thank you for your consideration, Your Honor.
Thank you, Mr. Quistorf. And I think there's some tissues.
I'm good. Thank you.
Mr. Quistorf, we all make mistakes in life. Nobody's exempt from that. And you know what I usually tell people, I know you've not been here before, but how we measure ourselves is how we make up for our mistakes. We pick ourselves up, we brush ourselves off, we go on, we do better things, we learn from our mistakes. We try to pay good forward, and that's all we can do. Everybody makes mistakes. This was not an aggravated mistake, meaning, you know, you didn't take a piece of pipe and go swack somebody over the head, something of that nature. But this is not something that a community wants and, you know, wants going on out in the community.
It did involve a piece of pipe.
So law enforcement works swiftly here. A lot of people got in the same trouble. You're not the only one. I think you're the third one in this category I've seen today. So this is something we can't have going on in the community. This is something that doesn't belong in the public. If it's going to go on, it stays behind private doors where you have privacy. In regard to the matter, though, you are forthright. You seem very forthright. You seem like a responsible citizen. You've made it to 62 years of life without any brushes with the law. And I think the recommendations are appropriate. You should be given that opportunity to demonstrate that this is a one-time error in judgment that you will not likely repeat. So I will impose sentence under the general delay of sentence status, that's 771.1, whereby if you get through your term of probation successfully, this would not appear on your record as something that John Q. Public could access. Of course, police remain accessible, the prosecutor's office, the court. It stays available to the inside parties, but an employer, for example, could not open it up and try to find that, right?
Thank you, Your Honor.
So that's why I think a period of probation is appropriate, even though that it is one of these types of charges that is a presumptive non-probationary type of charge for the reasons One, that it was reduced from a felony to a misdemeanor. Two, the nature of the misdemeanor. And three, the fact that I'm giving you an opportunity to keep this off your record. All those reasons make a probationary period appropriate. 9 months, there's a $300 oversight fee. Attached to your paperwork you'll get today is a notice regarding early discharge from probation. It explains what steps are necessary to achieve an early discharge, and it also explains what types of cases are exempt from early discharge. If you have any questions after reading it, you may speak with your probation officer or your lawyer about it.
Thank you, Your Honor.
And I am going to then impose fines and costs then on the disorderly person of $340, $75 to the crime fund fee, $50 to the justice system assessment fee. That's $765. I'll order that be paid in full today. Is that what your lawyer said?
Yes, sir.
All right. I'm going to order 10 days in jail with credit for the 1 day you've already served. 9 days will be suspended if you complete 18 days of community service work. You can talk to the probation department about how to achieve that when you go down there after court. In addition to the general terms of your probation, which are going to be listed up here, yours are going to be yellow and copy on the top. Checked will be the following. You are not to loiter in any public place. You are not to use, possess, or access social media accounts or apps with the exception of LinkedIn, which is strictly for business purposes. You're not to be on the property of the Hydraulic Falls Park. Do you understand those conditions of your probation?
Yes, I do, Your Honor.
I'm going to read you your appeal rights, and it's on the back of the yellow sheet as well. An appeal to circuit court may be taken within 21 days from the date of your sentence or 21 days from today. That's an appeal as of right, or as permitted under Michigan Court Rule 6.625B, and that court rule has to do with permissive appeal as opposed to appeal of right. If your sentence includes incarceration, and if you wish to file an appeal but are financially unable to retain a lawyer on appeal, you can make application to Michigan Indigent Defense Commission / State Appellate Defender Office to see if you qualify for representation on appeal. However, that has to be done within 14 days of today's date. Do you understand that advisal then, Mr. Quistorf?
Yes, I do, Your Honor.
Do you understand the order of the court?
Yes, I do, Your Honor.
All right, you're going to receive that in writing here before you leave. We'll send you down to the clerk and the probation. Is there anything else, Attorney Muir?
No, thank you very much, Your Honor.
Thank you. Ms. Cass?
No, Your Honor, thank you.
All right, thank you. We'll
Thank
be
you.
off the record.
Very much, Your Honor.
Thank you.
Remember, you look marvelous.
Okay, you are Mr. Plamp, is that correct?
Yes, sir.
All right, Mr. Plamp, you're here with Mr. Johnson, your attorney. Also here is Ms. Henry, the clerk. Ms. Janes is our court reporter. We have Mr. McHugh here from the department. Mr. Johnson, you've had an opportunity to discuss this matter with your client, is that correct?
I have, Your Honor. As to the underlying violations, he would waive the right to call witnesses, have a hearing formally at this time, and he would be admitting to the violations and providing an explanation to the court.
All right, we're starting a little bit early. We're 4 minutes from the period at which this was set. Is there any objection from Mr. Johnson or the department to proceeding at this time? Mr. Johnson?
No, Your Honor.
And the department?
I have no objection, Your Honor.
All right, thank you. Okay, let me go to you then, Mr. Plamp. It's been explained to me by your attorney that you wish to go ahead and plead guilty to the charges that have been filed against you by the probation department. Those charges are a probation violation. There are 3 counts. The counts are that you had contact, number 1, with Rachel Wilcox and violated your order, and that you had ongoing contact with her. And count 2, they allege you violated condition 23 by changing residences without authorization. And in count 3, that you not violating the criminal law, they allege that you possessed methamphetamine on October 19th of 2023. As I understand it, you intend to plead guilty to those charges. Is that accurate?
Yes, sir.
You understand that the underlying offense that you were convicted of is third offense domestic violence. It's a 5-year felony here in the state of Michigan, and you're subjected to penalties within that period. Do you understand?
Yes, sir.
All right. In that case, please raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Help me God.
Okay, you read and understand the English language, correct?
Yes, sir.
You can hear and understand me now?
Yes.
Mr. Johnson is your attorney, and you've had a chance to discuss with him the charges that have been filed against you and any possible defenses that you might have to those charges, correct?
Yes, sir.
And you're satisfied with his advice, true?
Yes, sir.
All right. Have you had any drugs, alcohol, or substances that might affect your judgment in the last 24 hours?
No, sir.
So you understand that at each and every phase of this process, you've got the right to your own lawyer, and if you can't afford one, that I would appoint one for you at the public's expense.
Yes, sir.
You've also got the right to have a hearing on these charges today. At that hearing, the department will present evidence as to why they think you're guilty. You'd have the right to cross-examine their witnesses and present your own defense. At the end of that hearing, I would make a decision based on
Don't worry, we're warming up. It gets there.
a preponderance of the evidence standard. That's a tipping of the scales, 50% plus a little bit. If I thought the department met that burden, I'd find you guilty. If I thought they had not met that burden, I would find you not guilty. Do you understand that, sir?
Yes, sir.
All right. Do you understand that, hold on. It looks like we have the victim here as well. Let's go ahead and bring her in, please.
There we go. Let's let the victim in. Spice this thing up a little bit.
Okay, you are Rachel Wilcox, is that correct? Ms. Wilcox, can you see and hear me?
Yes, sir.
All right. We began just a little bit early on this case. We have been in discussion with Mr. Plamp. He is going to admit guilt with regard to the 3 counts that have been filed against him. We've just been going through those counts. Okay, that's where we stand. You are welcome to observe.
Okay, the defendant's already going to admit guilt to 3 counts. But that is not going to prevent her from dunking on him.
I'll be back with you in just a few minutes, okay?
Okay, thank you.
All right. Okay, sir, you understand that if I accept your pleas today, that a conviction will enter against you on all 3 of those charges.
Yes, sir.
And has anyone made any promises, threats, or any other untoward advances in order to get you to plead guilty to these charges?
No, Your Honor.
Are either Mr. Johnson or the department aware of any promises, threats, or inducements that are not part of the record?
No, Your Honor.
No, Your Honor.
And Mr. Plamp, are you making this decision to enter pleas of guilty to counts 1 through 3 of your own free will and your own free volition?
Yes, Your Honor.
And are you doing so because you are in fact guilty?
Yes, sir.
All right, let's talk about what happened. Count 1 alleges that you violated condition 31 by not having contact, or pardon me, by having contact with Ms. Wilcox. Is it true that during the months of July and August of 2023, you were having contact with Ms. Wilcox?
Yes, sir, Your Honor.
All right. And in count 2, they allege that you failed to report a change of residence without authorization. Is it true that on or about July 1st of 23, you changed your residence without getting authorization from the department?
Yes, sir.
And in count 3, they allege that you violated condition 1, which requires that you not violate any criminal law, in that on or about October 19th of 23, you possessed or used the controlled substance methamphetamine. Is that true?
Yes, sir.
And I should have asked you this before, but you understand that by entering these pleas today, I don't know whether you're on probation for some other count, parole or bond, but that information could be used in order to take action with regard to those matters. Do you understand that, sir?
Yes, Your Honor.
Okay. And you're sure that substance was methamphetamine? Is that right?
Yes, sir.
And where did you possess it?
I believe it is a true use, Your Honor. I spoke with Agent McHugh, and I believe he tested positive, but the language he put in the violation implied that he would have had to have possessed it to use it.
Understood. So, sir, you knowingly possessed the substance methamphetamine, is that right?
Yes, sir.
And you used it, is that correct?
Sir.
And this occurred on October 19th of 23?
Yes, sir.
All right. I guess I should ask you this, Mr. Johnson. Are there charges coming with regard to that matter as far as you know?
There are not, and that's why I specified that I think the language, that was my concern initially, was that when we have possession, we have cases. When we have use on probation, typically we don't. But I don't think that there was actually any methamphetamine found. I think it was a positive test.
Understood. Well, are there any additional questions regarding the factual basis, Mr. Johnson?
No, Your Honor.
And for the department?
No, Your Honor.
And the parties believe the court has complied with the court rule?
Yes, Your Honor.
All right, sir, it's now up to you. As to the charge that you did on or about during July and August of 23, violate condition 31 of your order of probation by having contact with Ms. Wilcox, how do you plead?
I plead guilty, Your Honor.
As to count 2, that on or about July 1st of 23, you violated condition 23 of your order of probation by failing to get authorization from the department to change your address. How do you plead?
Guilty, Your Honor.
And as to count 3, that you violated condition 1 by on or about October 19th of 23 using the controlled substance methamphetamine, how do you plead?
Guilty, Your Honor.
Well, based on our conversation, it's clear that you understand your right to hearing, you understand your right to counsel, and it's also clear to me that you violated your probation in the ways that we described. I'll accept your pleas. I think they were knowingly, intelligently, voluntarily, and understandingly given. Judgment of guilt will enter as to count 1, count 2, and count 3. Now, the next step in the process is for me to get an update as to your status. I think that's going to be useful in this case. The department will prepare a short memo outlining your status, how your probation has been going. I'm going to use that in order to make a good decision regarding sentencing. So you'll get a chance to review that document. If you see something inaccurate, tell Mr. Johnson and we'll discuss it here at sentencing, which will be set in about 5 to 6 weeks. Do you understand?
Yes, sir.
All right. Mr. Johnson, is there anything else that we can address today, sir?
Bond, Your Honor.
Let's talk about bond.
Your Honor, obviously, there's no presumption of innocence or anything like that as to these violations. He has admitted to these violations. By way of providing a little more information, I believe the reason Ms. Wilcox is here is I think that earlier in the case, they were allowed to communicate for purposes of child exchanges, I believe specifically regarding a child of Mr. Plamp's that is not a child of Ms. Wilcox, but that she was helping to take care of. So I also believe that she's the one that informed the court about the use, and it was her concern, and she wanted to make sure that that use was not continuing, and certainly applaud her for doing so. And she had no doubt has seen the articles in the paper of people overdosing and dying, and I think that was very responsible on her behalf. And my client, quite frankly, told me he was very grateful that she had come forward and given that information. So they did have contact. We're not denying that. As to moving residents, I think my client did try to reach out, but didn't get the authorization and just went forward with the move anyways. And then obviously we have the positive test. What I'd note about the positive test is that he indicates that's the first time he had been tested in about a year, or perhaps even more than that. So what I would be asking for, Your Honor, would be a bond to be set of a personal recognizance varietal at this point in time, but with testing. I would like to see 4 to 8 times a month random testing for Mr. Plamp. I think that would be good, not only obviously for himself, but hopefully for Ms. Wilcox as well, to make sure that if he's out and about, he is clean and sober and he's not risking his lives or putting anybody else at any sort of serious risk. He's had no other issues on probation. He's been on probation for some time. So I do think that a personal bond here would be appropriate, and I think it would be enlightening, quite frankly, to the court as to what potential sanction should come from this violation.
All right. Is he working?
Mr. Plamp, are you working currently?
I was working at Sierra Lee since January.
All right.
And you do have a place to stay as well, correct, Mr. Plamp?
Yes, sir.
Not with Ms. Wilcox, correct?
Correct.
No, but I would like a few words at some point, please.
All right. Hold tight, ma'am. Okay. Let me hear
Oh, don't worry. She gets him in.
from the department, please.
Your Honor, excuse me, Your Honor, I can't remember if you were present at the arraignment for Mr. Plamp or if it was Judge Hamlin, but I did state during that arraignment, Mr. Plamp started out well. He was doing great. Completed ATS, was living in ATS housing. Really where he went wrong is when he left ATS housing. And he falsely reported an address that I think maybe he stayed at for all of a week before moving in with Miss Wilcox, excuse me. He still appeared to be doing well until just recently when the violations were brought. So, I mean, I do believe that he can be supervised on bond. You know, he was brought before the court because his drug use was out of control, and he wasn't being honest with it. And I feel that we could probably move forward with the defendant on bond, Your Honor, as he's had some time to sober up now and kind of refocus.
All right. Thank you, Mr. McHugh. Ms. Wilcox, I'll go ahead and hear you since you're the victim on this. I'd be glad to hear what you have to say.
Thank you, sir. I appreciate it. I agree with them. He has a lot of good in him, Your Honor. I don't know what it is about the drugs that keeps dragging him to it, but I don't think him sitting in jail is helping him. I think he needs more treatment. I know him better than anyone. He needs more treatment, and he definitely needs more supervision out in the community. He had been doing drugs for at least 2 months that I know of before his probation officer, before I even contacted his PO. So, you know, he was out getting away with it for a while, and you can lie all you want, but he was also selling it. And I don't care.
I need you to stop right there because he hasn't been charged with that. And
okay, that's
fine. I'm not saying, hold on. I'm not saying that didn't happen.
No,
what I'm telling you is that I really need to focus on the issues that are before me, and that's can he be supervised on bond? So you can go ahead and
I think he would be, but he just needs more supervision. And I thought it was my idea for him to come here and stay with me because that address is not a good place for him to be. And it literally is the only place for him to stay in Traverse City. He doesn't have anywhere else to go other than me or Leah's house. He really don't. He don't have any friends and really no one else. So, but Leah's not, I don't know how she lives, but I know I live clean and I don't do drugs here and I don't want it here. So I'm the one who asked him to come here and stay because I thought it would keep him clean, but obviously it didn't. Obviously, me and his son weren't enough for him to stay clean because he got that job at Sara Lee. And I think that there's people, actually I know because he told me, the people that work the third shift there do drugs. And so he ended up getting involved with it there.
No, don't tell me third shift at Sara Lee's doing drugs.
But he has to learn to be able to stand up and walk away from that type of stuff. You have to, Johnny, or Dennis. You have to. Like you're
okay, Ms. Wilcox,
man.
That's enough. I appreciate your information. It's very, very helpful.
Thank you.
I believe her in her way. I actually think she's sincere, and I think she's telling the truth. However, she will not shut up.
Let me ask you this, Mr. Plant. If you're not going to Ms. Wilcox's and I release you, where are you going?
2185 Friendship Drive, Traverse City, Michigan.
All right. And whose residence is that?
My cousin, Leah's.
Okay. And is Leah a felon?
No, she isn't. She's a nurse at Munson.
All right. And to your knowledge, is she, and I can put you under oath, is she, I think that you are under oath, pardon me, is she using any kind of controlled substance unlawfully?
Not that I know of, Your Honor. I don't see her much. She works third shift and I work third shift, so
ask him she ever.
Just
well, ma'am, I can't. Hold on, Ms. Wilcox. Listen, I'm kind of breaking protocol by having you here. Okay. So I appreciate.
I know her and I know her.
Okay, I'm gonna have to put you on mute if you don't listen to me. All right. We're conducting a court hearing. This is just like you're in court. It doesn't seem like it because it's electronic, But in court, I'm in charge, and you just have to wait for me to call on you or not call on you. And if I tell you to stop, you've got to stop, okay?
Yes,
We're
sir.
making a word-for-word transcript. It's impossible for the court reporter when you and I talk over each other. I know you've got strong feelings, and I appreciate them. I've got it, okay? I get it. But at this point, it's time for me to make a decision. I don't need any additional information from you. If I do, I'll call on you, okay? Mr.
I
McHugh,
would.
did you have any
Can I
additional?
say one
Hold
last
on,
thing?
hold. I guess you don't understand what I just told
Yes,
you.
I
Let's
do.
put her on mute, please. I hate to do that, ma'am, but I just asked you not to make comments unless I called on you. All right, Mr. McHugh, you had some additional information. Is that right? Or did you have anything else you wanted to let me know about?
Your Honor, I was just going to relay that. I think what Ms. Wilcox is saying is that she does have her concerns with the placement that he's alleging to go to.
Understood. I got that. Do you have any specific information, Mr. McHugh, with regard to this address or with regard to this person?
Your Honor, in all honesty, the information I have came through Ms. Wilcox. She alleges that both Mr. Plamp and his cousin, who apparently really isn't his blood cousin, were both using and dealing methamphetamine out of the house.
All right. Well, that's enough, as far as I'm concerned, not to allow you to stay at that location. Mr. Plamp, where else? And by the way, remember that location has to be approved by Mr. McHugh. So where else would you be going if you're not going to Ms. Wilcox's place? She's the victim, and you're not going to your cousin, quote unquote. Where would you be going to stay?
The hotel?
Do you have any resources to go to a hotel?
Yes, I do.
All right. Here's what we're going to go ahead and do. I'm going to go ahead and release you on a PR bond. I'm going to require that you report for testing 8 times per month. And Mr. McHugh, I'm wondering about a GPS unit or a reporting unit. Do you have any recommendations with regard to a unit that he could use?
Yeah, we do have units available, Your Honor, and I could utilize that unit.
All right. I'm going to want you to also have a unit on, a GPS unit. It may be a testing unit. That's going to depend upon what they have available. Go ahead, Mr. McHugh.
I'm sorry, Your Honor. The GPS unit won't test him. The GPS unit will just track and restrict movement.
I'm more concerned about testing. So if we've got a testing unit available, do we or do we not?
We don't have one for drugs, Your Honor. That seems to be the nemesis here. We have the alcohol bracelets. But it seems to be, I think the common factor through Mr. Plamp's time with our department so far has been methamphetamine and heroin and other drugs like that. So, I mean, I can have him come in weekly and test.
All right. Maybe that's the better solution. I'm going to have you come in weekly for testing with Mr. McHugh. We won't put a GPS unit on. It doesn't sound like that's the issue. And you should understand, sir, that if I get the slightest sniff of a violation, either based on the testing from Mr. McHugh, based on any other reporting, and believe me, I think Ms. Wilcox will come in and report anything that she knows about if you're violating, you'll be right back in and we'll be holding you until this matter is resolved. Do you understand that, sir?
Yes, Your Honor.
You are on a very short leash. I'm going to want you to go back to work. Maybe you need to think about working somewhere other than Sara Lee. I know it's a good job, but if you're around people that are using, that's not in your best interest. That's not.
Okay.
All right. It's just going to make your life more difficult, and you'll wind up spending more time in the O'Shea Hotel across the street. Okay.
Yes, sir.
All right. That's what we're going to go ahead and do in this case. Otherwise, all the normal bond restrictions will be in place. Is there anything else that we can address with this matter, Mr. Johnson?
No, Your Honor. Thank you.
And Mr. McHugh?
No, Your Honor. I believe the court has covered everything.
All right. Thank you. Mr. Plamp, we'll go ahead and try to take care of the paperwork before the end of business today. Ms. Henry, did you have something else?
Yes. What is the PR bond amount?
Let's set an amount. Thank you. We'll go ahead and set an amount of $1,000 for that PR amount. What that means, sir, is that if you violate, then you owe the court that $1,000, okay? And Ms. Wilcox, I'm sorry I had to cut you off, but thank you so much for your assistance today. It was very helpful. All right. Thanks, everyone. Have a good weekend.
Thank you, Judge.
Thank you.
Any objection? All objections.
Yes, Miss Wilcox, you were helpful until you weren't. I don't have my mic on. I figured that out halfway through the stream. Y'all probably can't hear me. Sorry about that. You know, these things are going to happen when you're on the road. I streamed from 2 different towns in South Carolina today. Okay. We had fun on Big and stream earlier. Oh, that was something else. And this one took a while to develop, but I think Miss Wilcox saved it there. I really did. I like the judge. Oh, I'm too familiar with this. Up in Traverse City, there's no industrial base, so there was a large whatever. Traverse City has a bunch of fruit and cherries specifically, and they make pies and all this stuff. And then that is a big employer, and it used to be called Chef Pierre. It was taken over by Sarah Lee, and it's like one of the few places you can go and make okay money if you're unskilled labor. Those are the facts. So this guy has no other options in Traverse City. I guarantee it. I guarantee it. He's either doing meth on the third shift or he's not working at all. That's my guess. I don't know. What do I know? What do I know about anything? Well, that was fun. Yeah, the other one, the other case out of Dickinson County there. You guys are killing me with the with the operation names. Operation Bone Drone and the like. You know what I'm saying. Thanks a lot for coming out. I appreciate it. I'll see y'all soon.